the first to know in Nsem-Pii TV.
On the rising tension on the removal of the Chief Justice, Justice Araba Sewa Tukono. Now, for the mighty minority, Asheki Jubilee House with a letter, just raising 5 solid point issues. 1. A clear violation of due process or pending judicial review. Awiei na beto odwa as a John Dramani Mahama was suspended a Chief Justice. Na Ghana ha asɛm bi aba ana court mmara mu no asɛm bi aba wodi bemo wodi fo asa asɛm no enya kopie mu court a ɛsɛ wogya ma court di asɛm no. But in this case asɛm wɔ court yɛ niwe yɛ nso Mahama egu so a otutu anamon a mighty minority say ɛyɛ unconstitutional na ɛyɛ a coup on the judicial system. Nti Mahama ɔntwɛn say judiciary no on the 6th of April wɔn meet a ɛwɔ court a ne court ɛbɛka no ansa na Mahama atimi atoa the removal process no so sɛ court ma ne ho kwan a. Second point no so say ɛyɛ politically motivated which hand to control the judiciary. NDC for raised several issues even before elections. Say, I'm can say me say now down Akufo-Addo appointed a lot of judges. Bamako occupy Supreme Court one now MPP for, and until omo control judiciary into almost per se. Be appointed omo Nkrofo no omo control judiciary. Na no na minority say. Sansem no omo keka no. Enya nsem a ometena ho ahwe. Ama Mahama atimi no, third one will say a warning to Mahama administration: we will resist this judicial coup. Judicial coup anything. Omotu omani ade asi judiciary ni so. Omotu omani ade asi judicial system ni so. The legal fraternity, the civil society, and all defenders of democracy will not stand idle by while the judiciary is turned into an appendage of the executive. In fact, the 3 arms of government are the judiciary, the executive, and the legislative. Obiara ne powers. But in this case, the executive and the presidency per se, judiciary no are under their control. And enya dia omo mighty minority o metena wa hwe. Emma bibisas. And the fourth one is also call to action: uphold the constitution and defend judicial independence. Also, we demand the immediate reinstatement of the Chief Justice pending the Supreme Court's determination of the pending legal challenges. And the second one was a halt to all process proceedings until the judiciary has conclusively ruled on the constitutionality of the process. The integrity of Ghana's judiciary is non-negotiable. We shall vigorously oppose and all attempts to turn our courts into political tools. Enough is enough. Now, and somewhat mighty minority ado to Ghana yonko na yonko tie. Abra na lawyer bafo awua. Manshia MP. Any OB atwetwe nkɔmɔ afa wɔn na explanations a ɔde maa no yɛnkɔ na yɛnkɔ tie.
Ebi aya bebree question you na mebisa. Question no ne fapem ne nea egyina article 1416 ho. Any article 296 any article 23 of the constitution. So share article 1416 now. The can say our president in them say establish the Council of State or the Council of State establish a prima facie case now. Our president is some say on the advice of the
Council of
State or move to me as suspended Chief Justice.
Sure.
And these are
sure.
Where the use will eliminate.
Yes.
may enso emremu no discretion.
Yes.
A chrese utumi so ye anaso utumi se onye.
Yes.
Good. Article 296 no of the 1992 Constitution no. So, Mama Koina me reading chiro. The exercise of discretionary power. 296. The exercise of discretionary power. Ekono nyansa ba kwa ewumune say will be exercise discretionary power. That discretionary power no. The who exercise here. It was a exercise no. Ekwaya sabi and I said Osada also say ube acting in a manner that is fair and candid. So what I say now send your beya you know who say all acting in a manner which is fair and candid no. There must be a regulation. So what I say in now was where the person or authority is not a judge or other judicial officer. Just a nipa or exercising discretionary power no. So when you judge and answer on your judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent to the provisions of this constitution or that other law to govern the exercise of the discretionary power. The part or your president or a judge.
Dabi.
Your president or judicial officer.
Dabi.
A child will say, "Sir, to me now or exercise, there should be a regulation that should guide it." Is there a regulation that is guiding it?
Yeah, but Article 146, this will not be the first time the head of an independent constitutional body be go through. And see, if former presidents were not minded to put in place our regulations now, why do you blame this one for it?
The former sebi. Constitution, it doesn't make an exemption. Constitution, say obi a breach constitution, that will be a challenge. It doesn't make it right. Say, assume see amasem into there is no immunity for the breach of the constitution. So I say, the constitution is being breached. This suspension, in the absence of a regulation, breaches the constitution. Sabi, see breaching on your it doesn't make it right today. So I say, the suspension of the Chief Justice, right, to begin with, in the absence of a regulation or a law to guide the power of the president to suspend the Chief Justice under Article 296, under Article 14610, is a breach of the Constitution. Secondly, what went into the suspension, right, was it done in a manner which is fair and candid? How are we supposed to know? Because the thing, right, is in camera. It is the more reason why there ought to be a regulation for the performance of that duty. So what I say. The fact that it is in camera, no, it is the more reason why it cannot be done in the absence of a regulation, a published regulation, which informs Ghanaians that this is the procedure by which a Chief Justice may be suspended by the president. These are the grounds upon which he might be suspended. So what I say.
Yeah, but now, Oshe 296 na lawyer. The exercise of discretionary power generally. When you come to 14610, specifically when it comes to the CJ, actually what should happen in suspending the CJ? And it says the president on the advice of the Council of State may. If the president has gotten the advice from the Council of State, which is a requirement, now the president is minded to want to go ahead with the suspension until Mra, especially when it comes to CJ. Yes. Yes.
Does it cease to be the exercise of discretionary power simply because he's receiving advice from the Council of State?
No, but there is an express mention.
Tobo. This is constitutional interpretation.
Sure.
Tobo.
Sure.
Okay. What we should 296 right? Does it say subject to 14610?
No.
Does it say that?
No.
Does it? So it doesn't make exclusion for the president's exercise of power under 14610. So I say, you see, it is talking. The only exception in here is the exercise of discretionary power by the judiciary or by a judge or a judicial officer.
Yes.
So if it was making an exception for the president under 14610, it would have said subject to 14610. Go through the Constitution. You see, constitutional interpretation, there must be harmony among the various parts of the Constitution.
Yes.
So
yes.
And so go through the Constitution. Wherever an exception is created, it does so, right? By either stating so expressly or stating subject to. Which means that it would have created an exception under 296. Just because you are receiving the advice of the Council of State doesn't mean that you are exempted, right, from the exercise of the regulation that guides the exercise of discretionary power under 296. The more reason why you are not even exempted from it. Don't forget that under Article 123 of the Constitution, justice, right, emanates from the people, right, and it is administered for and on behalf of the people by the judiciary. And Chief Justice, she's not there for herself. She's there for the people of Ghana. And so when you are doing a process in camera, then all of a sudden, you say you have suspended their Chief Justice. The Chief Justice is the Chief Justice of the people and not the President. And so he's gotten it wrong. There ought to be a regulation so that the people know ahead of time that this is the circumstance under which our Chief Justice may be suspended under Article 14610. Where is it? Now you have suspended the people's Chief Justice. You have suspended the people's Chief Justice. While the Chief Justice is appointed, approved by Parliament, he is no longer the nominee of the President. He is now the Chief Justice of the Republic of Ghana, the people's Chief Justice. Now this whole process, Parliament is even not involved. You and I know that under the Constitution and indeed the Interpretations Act, when power is vested in a person, right, that person has also the power to disappoint. And so it should go through the same process. Now, Parliament is not even part of this process. There is the regulation, the existence of the regulation would have made Parliament part of it indirectly. Now, there is no regulation. You say you have suspended the Chief Justice. It is an unconstitutionality.
Would you... Okay, instead you made a point earlier. In the case of Loretta Lamte, we know Charlotte said she was not suspended. She went through the process while still being chairperson of the commission. Loretta Lamte, she was made to step aside. But you made a point, say, if the constitution is breached, then it doesn't mean it should be breached now. My other question to you is, again, because they share interpretation, the exclusio unius rule in interpretation, you don't think it will find expression in 14610?
No, I don't think so.
The express mention of...
You see, you need to look at the purpose. You need to look at the purpose, right, of 146. The purpose of 146 is to remove a Chief Justice appointed under the Constitution, right, to become the head of the body which is the custodian of justice, which is entrusted to them by the people.
Nsem-Pii FM.
So they are saying.
Yes.
If you cannot do that with a secret process which doesn't have a clear regulation that regulates it.
No, but you also know, sir, the secrecy of the process, no, and because of weighty and a secret. There have been decisions of the court in Ghana established the fact that going through 146, no, the process should be in camera. Was say, so even the petition
that
and the details of the petition
in
should
doubt.
not.
You see,
Yes.
when you address to that, please.
Yes.
Now, I'm going to say that is what we are debating. That is what we are debating. What is the purpose? What is the purpose of the appointment and its procedure of a chief justice?
Okay.
Is to satisfy a certain philosophy,
okay,
which is that justice emanates from the people and it is held in trust by the judiciary, right, for and on behalf of the people. And so the appointment procedure or processes, it even involves the people's representative.
Okay.
Do you understand?
Yes.
You are removing her. You are removing the people's chief justice. The minimum or the minimum level or degree to which the people can get involved is the existence of the regulation.
Yes. Which
the
regulation will spell out process? I was saying, OFEM.
The circumstance, even the grounds. What I say, because say chief justice is free office. No one saw the light as she may be causing financial loss to the state. But would that be sufficient grounds for her removal, right? And also her suspension? Look, let me tell you something. Go to the Constitution. Go to the provisions that govern the appointments of Superior Court judges and even the Chief Justice. Go and see whether, for instance, the qualification, is the Constitution spells out what goes into the qualification. It doesn't say so.
Yes.
The grounds for the removal of the Chief Justice, right, stated misbehavior. What is the offense called stated misbehavior? You and I don't know.
Yes.
You and I don't know.
Yes.
Right?
Yes.
So, today, if there is an in-camera procedure to remove our Chief Justice, right? And don't forget, you see, we need to qualify it. The Chief Justice is the people's Chief Justice. It's not the executive Chief Justice.
Yes.
So what I say.
Yes.
So then the executive will be removing the people's Chief Justice, whose appointment they had a say in it. How do the people have a say in the removal? It is through the regulation. It is through the regulation.
Because the regulation will go through Parliament.
It will go through Parliament. Parliament will then approve and say that this is the grounds for removing the Chief Justice. These are the ingredients of the constitutional grounds for removing the Chief Justice. These are the grounds, right, for suspending the Chief Justice. All that will be in there. Today, how do we determine whether or not the suspension is fair and candid? Because the Constitution requires that the exercise of the discretionary power should be fair and candid. How do we determine it? So the suspension is unconstitutional.
Based on the argument you've put forth so far.
Based on the Constitution, not my argument.
No, your argument based on the Constitution.
Yes, based on the Constitution, which requires that the exercise of the discretionary power, right, must be fair and candid, must not be arbitrary and capricious. There must be a published guideline by way of a regulation or law that will govern it. Based on the Constitution, which doesn't create an exception for any other person apart from the judiciary and the judicial officers, right? Even if we're to take it that the advice of the Council of State qualifies in this regard, what informed the advice of the Council of State? There should be a regulation. There's no exception for the President and the Council of State